are going to talk about a very important topic. The classification of cases and important jurisdiction in India. These two concepts, they help us to understand how justice is delivered in our country. Every case, whether it is a civil case or criminal case, every case follows a certain path in the court system. The powers and duties of different courts, especially the Supreme Court, they are guided by the Constitution of India. Understanding how cases are classified and which court has the authority to hear them, it is important for every citizen. Let's explore this topic in detail. The Supreme Court of India, it plays a very important role in protecting justice and the Constitution. Every year, thousands of cases, they come before the Supreme Court from different parts of the country. To manage these cases efficiently, the court classifies them into different types. This classification, it helps in organizing the cases properly and allows judges and legal officers to handle these cases according to their nature. For example, some cases are about civil matters like property or money disputes, while other cases they deal with the criminal issues like theft or murder. Some cases are special appeals or petitions, and some are transferred from other courts. Each type of case, it has its own category and a short form or abbreviation to make it easier to identify. So, we will explore the main types of cases handled by the Supreme Court today. Let's understand what they mean and let us learn why this classification system, it is so important for justice and order in our country. To handle this variety in orderly and fair way, the court uses a system of classification. This helps judges, lawyers, and even common people to understand what kind of case is being discussed. Each case type, it has a special purpose, and understanding these can help us appreciate how justice works in our country. In these different categories, let us start with arbitration petition. Number one, arbitration petition. This is used when two parties have a disagreement, like a business deal gone wrong, but instead of going through a long trial, they want a neutral third person to help them solve it peacefully. The Supreme Court can step into, appoint or support this arbitrator. Then second type is the civil appeal. The civil appeal is for people or companies who are not satisfied with the judgment of lower courts. These cases are about things like property, personal rights, contracts or money. The Supreme Court is asked to check whether the lower court's decision was fair and correct. Then we'll see the third type, a contempt petition, civil. It is filed when someone disobeys the orders of the court in civil matters. For example, if the court tells someone to return land or money, but they refuse, the other party can bring this type of petition. Then we'll see the fourth one, in a contempt petition, that is criminal. A contempt petition, criminal. In this, the person may have done something very serious that harms the respect and the authority of the court in a criminal case. This can include threatening a judge or disturbing a trial. Then we'll see the fifth type, a criminal appeal. It is filed by someone who has been found guilty of a crime but believes the decision was wrong. This allows the Supreme Court to review their punishment or the entire judgment to ensure justice. Now we will move to sixth type, an election petition. An election petition deals with the problems that happens during elections. These cases, they question if the election was framed, if cheating occurred, or if the candidate was legally qualified to contest and win. Then we move to the seventh one, an original suit. Original suit, it is a unique type of case where the Supreme Court hears the case directly without it coming through other courts. These usually involve legal fights between states or between the central and the state government. Then eighth one, a petition for special leave to appeal. It's a civil. A petition for special leave to appeal, civil. It is a request made when someone loses a civil case in a lower court and wants special permission from the Supreme Court to appeal that decision. Then we see the ninth one, a petition for special leave to appeal. It's a criminal. Then this type of case is similar but for criminal cases. It gives a person one more chance to ask for justice in the highest court after losing in lower courts. Then we move to the 10th type of case, a special reference case. Special reference case, it happens when the President of India asks the Supreme Court to give its legal opinion on very important questions, especially those that affect the whole country. Though the court's answer is not always binding, it carries great weight. Then we move to the 11th type of case, a transferred case, civil. A transferred case, civil, is a civil case that was being handled by a lower court but it is moved to the Supreme Court. This usually happens if the case is very important or if the case is very complicated. Then we'll move to the 12th type. Then a transferred case, it's a criminal. Transferred case and criminal category. A criminal category case, it is a matter that the Supreme Court takes over from a lower court. This might happen for reasons like ensuring safety, fairness, or national importance. Then we move to the 13th type of case, transfer petition civil. It is when a person asks the Supreme Court to move a civil case from one court to another, maybe because they fear bias or because the location is too far or unfair to one party. So because of various reasons, this transfer petition can be used in civil category. Then the same transfer petition in criminal, that's a 14th type. It is used in criminal matters for the same reason. Someone might feel unsafe or that they want to get justice in the present location or so they request a shift to another court. Then 15th type case is tax reference case. It is about problems or confusion related to tax laws. These are brought to the Supreme Court so it can give a clear answer that applies to all similar cases in the country. Then 16th type is a writ petition civil. It is a powerful tool that lets citizens approach the Supreme Court when their basic rights like the right to education, right to equality or free speech, they are denied. The court can take quick action and give special orders to protect those rights. Then we'll see the 17th one, a writ petition criminal. This category type, this type of case is filed when someone's criminal rights are violated. For example, if someone is arrested without a reason, kept in jail unfairly, or denied a fair trial, they can come to the Supreme Court for protection. Then we'll see the 18th type, a review petition civil. This type of case is used when a person believes that the Supreme Court made a mistake in a civil case. The same court is asked to review its own judgment to make sure justice was done. Then 19th one, a review petition criminal. This type of case works the same way, but it is used for criminal cases. It gives the accused one last opportunity to ask the court to carefully recheck its earlier decision. Then the 20th type is if even the review petition is dismissed and someone still feels that a serious injustice has happened in civil case. Now they can file a punitive petition civil. This is the last legal hope to correct any error that causes great harm. Then 21 finally is a curative petition criminal. A curative petition criminal. It is the last possible attempt to give justice in a criminal matter. It is only allowed in very rare and exceptional cases where the court agrees that something went very wrong earlier. This classification system may seem complex, but it plays a very important role in how the Supreme Court of India works. Each type of case, it helps the court to deliver justice in a focused and fair way. For citizens, knowing about these case types, it can help them understand how their legal system functions and how they can seek justice no matter who they are or where they come from. Now let's talk about court and jurisdiction. The jurisdiction of the Supreme Court of India, it refers to the legal authority it holds to hear and decide cases. This jurisdiction, it can be broadly divided into different categories. Let's start with appellate jurisdiction and extraordinary appellate jurisdiction. The appellate jurisdiction of the Supreme Court, it means it's a power to hear appeals. It's a power to hear appeals from the decisions of lower courts. An appeal is a legal request made by a person who is not satisfied with a judgment and wants a higher court to review and possibly change the decision. Under the Constitution of India, the Supreme Court has been granted the power to hear such appeals in specific cases. These appeals are provided for under Articles 132, 133 and 134 of the Constitution. Article 132, it allows appeals in cases where there is a substantial question about the interpretation of the Constitution. Article 133 deals with the civil cases and Article 134, it allows appeals in criminal cases. The procedures for handling these appeals they are governed by Orders 19 and Order number 20 of the Supreme Court rules. Apart from constitutional provisions, the Supreme Court can also hear appeals that arise from laws passed by Parliament or state legislatures. These appeals are based on various statutes or various laws that are currently in force in the country. These types of appeals, they are governed by several rules laid out in the Supreme Court rules. Specifically, orders, they are number 19, 20, 21, 22, 23 and 24. These orders, they provide detailed procedures for how such appeals should be filed, heard and decided by the court. In addition to these, the Supreme Court has powers under a special law passed in the year 1970. It's called the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act. This law allows the court to hear criminal appeals even in cases that may not fall under the ordinary rules of appeal. This has extended the reach of the Supreme Court in matters relating to criminal justice. These appeals are processed under Order number 20 of the Supreme Court rules. Another important part of the Supreme Court's appellate powers, they come from Article number 136 of the Constitution. Under this article, any person can request the Supreme Court. Any person can request the Supreme Court to grant special permission to appeal, even if no regular appeal is allowed under the law. This is known as special leave to appeal. It is a unique and extraordinary power that the Supreme Court holds to ensure that justice is done. Justice is done, especially in cases where legal errors or injustice may have occurred in the lower courts. The court has the discretion to accept or reject such petitions. These cases are handled under Orders 21 and 22 of the Supreme Court rules. The second major category of jurisdiction is known as extraordinary appellate jurisdiction. This refers to those appeals which are not granted automatically by law but are allowed by the Supreme Court when it feels that the matter involves serious injustice or a significant legal question. They are also made under Article 136 of the Constitution, and they involve petitions filed by individuals seeking special leave to appeal. The procedures for such cases, they are also guided by Articles 21 and 22 of the Supreme Court rules. Now let's talk about the next category, original jurisdiction, Supreme Court of India. In addition to appellate powers, the Supreme Court of India, it also exercises original jurisdiction. This means that certain types of cases, they can be brought directly before the Supreme Court without first being heard by any lower court. This is different from an appeal. This is different from an appeal, where the case has already been decided by a lower court and is brought to a higher court for review. One of the most important aspects of the court's original jurisdiction, it comes from Article number 32 of the Constitution of India. This article gives individuals the right to directly approach the Supreme Court when their fundamental rights are violated. The Supreme Court can issue various kinds of orders or directions known as writs. These include the writs of habeas corpus to release someone who is unlawfully detained, mandamus to direct a public authority to perform its duty, prohibition to stop a lower court or tribunal from exceeding its jurisdiction, then quo warranto to challenge the authority of a person holding public office, and certiorari to review and quash orders passed by lower courts. Such petitions, they are managed according to Order number 38 of the Supreme Court rules. Another kind of original jurisdiction is exercised under Article number 131 of the Constitution. It allows the Supreme Court to hear dispute between the Government of India and one or more states, or between two or more states. These disputes usually they involve questions of law or constitutional interpretation. The procedure for these cases, it is laid down in Orders number 25 to 37 of the rules, which form Part 3A of the Supreme Court rules. Under Article 139A1 of the Indian Constitution, the Supreme Court can also hear petitions seeking the transfer of cases that are pending in the high courts and which involve the same or substantially similar questions of law. This helps in avoiding conflicting judgments and ensures uniform interpretations of the law. These matters are handled under Order number 40 of the rules. Similarly, under Article 139A2 of the Constitution, the Supreme Court has the authority to transfer cases, authority to transfer appeals or other proceedings from one high court to another high court. This is useful when there is a need for administrative efficiency or to ensure a fair trial. Such petitions are processed under Order number 41 of the rules. Apart from constitutional provisions, the Supreme Court also entertains transfer petitions under section number 25 of the Civil Procedure Code 1908. It allows for the transfer of civil cases or appeals from one state's court to another state's court, either between high courts or between civil courts. These petitions, they are also handled according to Order number 41 of the Supreme Court rules. In criminal matters, section number 406 of the Criminal Procedure Code 1973 gives the Supreme Court the power to transfer criminal cases or appeals from one high court to another, or from a lower criminal court under one high court to another court under a different high court. These transfers, they are governed by Order number 39 of the Supreme Court rules. The Supreme Court also hears petitions under the Presidential and Vice Presidential Elections Act 1952. If there are any disputes or doubts regarding the election of the President or Vice President of India, they can be brought before the Supreme Court under Article number 71 of the Indian Constitution and Article number 46 of the rules. This is a very special function that the Supreme Court alone is authorized to perform. Finally, under Section 11(5) of the Arbitration and Conciliation Act 1996, the Supreme Court has the power to appoint arbitrators in disputes where the parties have failed to agree. This function is performed according to the appointment of arbitrators by the Chief Justice of India scheme 1996 and is part of the Supreme Court's original jurisdiction. Now let's talk about extraordinary original jurisdiction. The Supreme Court also holds what is known as extraordinary original jurisdiction. This means it has the authority. It has the authority to take up special cases of national importance or of public concern, even if such cases do not fall under its regular original jurisdiction. One of the most significant examples of this is public interest litigation. We call it as PIL, public interest litigation. Under Article 32 of the Constitution, any individual or any organization, they can approach the Supreme Court in matters that affect the public at large. This is especially important in cases of environmental protection, human rights violations, and social justice. Such petitions do not require the person filing them to be directly effective. Instead, they are filed to protect the interests of others, especially those who may not be able to approach the court themselves. These petitions are processed under Order number 38, part of 3B of the Supreme Court rules. Another example of extraordinary original jurisdiction is when the Supreme Court is approached under Article number 32 to seek the transfer of cases involving the state of Jammu and Kashmir. Given the unique constitutional status and historical background of Jammu and Kashmir, special legal arrangements sometimes require the intervention of the Supreme Court to ensure that justice is maintained uniform. So, in summary, the original and extraordinary original jurisdiction of the Supreme Court, it makes it not just a court of appeal, but also a court of first instance in matters of vital constitutional and public importance. Through its power to issue writs, hear interstate disputes, transfer cases, and entertain matters of public interest, the Supreme Court of India, it upholds justice, unity, and the rule of law across the nation. Now, let's go to the next category, advisory jurisdiction. Advisory jurisdiction. Apart from deciding actual legal disputes, the Supreme Court of India, it also holds advisory jurisdiction. This means that it can offer legal opinions to the President of India and to certain legal bodies on specific issues, even if no case or lawsuit has been formally filed. This special power, it is provided under Article number 143 of the Constitution, and it is a unique feature of the Indian judicial system. Under Article 143(1), the President of India can refer any question of law or fact of public importance to the Supreme Court for its opinion. This provision is useful in guiding the government on matters where legal clarity is required for national interest or constitutional interpretation. The Supreme Court is not bound to answer such references, but when it does, its advice carries great authority and influence. These references are governed by Order number 42 of the Supreme Court rules. Under Article 143 of 2, the President may also refer disputes of the kind mentioned in this provision to Article 131, which involve the government of India in one or more states. In such situations, if the dispute is not suitable for litigation, it may still be referred to the Supreme Court for advisory opinion. This process too is handled under Order 42. Another important type of advisory jurisdiction arises under Article 317 of 1 of the Constitution. If the President believes that a chairman if the chairman or any member of a public service commission may need to be removed for misbehavior, the matter must be referred to the Supreme Court for an inquiry. This ensures that such high constitutional authorities, they are not removed without due and paid procedure. These matters are processed under Order number 43 of the rules. Furthermore, under the Right to Information Act 2005, the President or a Governor, they will refer cases related to the removal of the Chief Information Commissioners or Informational Commissioners to the Supreme Court. References by the President, they are made under Section number 14 of 1 of the Act, and references by the Governor under Section 17 of 1. Both are governed by Order 43 of the rules. The central government or statutory tribunals, they can also make references to the Supreme Court under various other laws, and these are managed under Order number 44 of the rules. Additionally, the Income Tax Appellate Tribunal, through its President, they may refer important questions of law to the Supreme Court under Section 257 of the Income Tax Act of 1961. These are governed by Order number 45 of the rules. Thus, the advisory jurisdiction of the Supreme Court, it ensures that constitutional bodies, the President and the statutory authorities, they have a reliable legal institution to turn to when facing complex legal uncertainties. Though advisory in nature, these opinions play a crucial role in shaping law and governance in India. Then let's talk about inherent and plenary jurisdiction. Inherent and plenary jurisdiction. The Supreme Court of India, it also enjoys inherent and plenary jurisdiction, which means it possesses complete and natural authority to do justice even beyond what is explicitly written in statutes or the Constitution. These powers are meant to protect the dignity of the court. Correct the serious legal errors, and ensure that justice is never denied due to a procedural technicality. One key example of this is the court's power to punish for contempt of court, which is provided under Article number 129 of the Constitution. This article states that the Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish anyone who shows disrespect or disobedience to its authority. This power is regulated to Section 3 of the rules to regulate proceedings for contempt of the Supreme Court, 1975. Another vital aspect of the Supreme Court's inherent jurisdiction is the power of review. Under Article 137 of the Constitution, the Supreme Court, it can review its own judgments if an error is discovered or if new facts arise that were not available earlier. This ensures that the court's decisions, they are not final if they are clearly unjust or incorrect. The process for filling a review petition is governed by order number 47 of the rules. In very rare and exceptional situations, the Supreme Court also entertains what are called curative petitions. This is a final attempt to seek justice even after the review petition has been dismissed. The concept of curative petitions was established in the landmark case, that was Rupa Ashokura versus Ashokura, and another 2002 SEC 388. A curative petition is considered only to prevent grave miscarriage of justice or to stop abuse of the court's process. These are governed by Order 48 of the rules. Lastly, the Supreme Court has the power to enforce its own decrees and orders under Section 2 of the Supreme Court Decrees and Orders, Enforcement Order 1954. It ensures that its judgments, they are not just symbols, but are actually implemented in practice across the nation. Together, these powers form the inherent and plenary jurisdiction of the Supreme Court. They act as safety valves in the legal system, allowing the court to uphold justice in extraordinary situations where ordinary laws or rules might fall short. The Constitution provides many specific powers to the Supreme Court. In conclusion, the classification of cases and understanding of the jurisdiction in India, it plays a vital role in the smooth functioning of our judicial system. The Supreme Court, it stands at the apex. It stands at the apex with powers that include original, appellate, advisory, and extraordinary jurisdictions. It can hear civil, criminal, and constitutional matters, enforce fundamental rights, and even step in for public interest through reaching special petitions. The Constitution has clearly laid out the responsibilities and powers of the Supreme Court, such as under Articles numbers 32, 131, 132, 133, 134, 136, 137, 141, 142, and 143, among others. This ensures that justice is accessible, fair, and effective for all citizens. The classification also helps us. The classification helps in deciding the nature of cases, whether they belong to civil or criminal branches, whether they should be handled at the district level, High Court, or Supreme Court. Through this structure, the judiciary remains organized and the rights of people are protected. Overall, the court and jurisdiction system in India, they reflect the vision of the Constitution, and it is a strong pillar of our democracy, committed to upholding justice for every individual.